for attending. This is, got it, my Scared Straight program. Before we start, got it. I called in so I can use my computer audio, and then I have my iPad so you guys can see me. So I need to be able to share my screen with the call in. I don't know if you're able to distinguish between the two, but the one that does not have a picture of me is the one that I need to share my screen on with the presentation. Oh, okay, I think we're good. All right. Everybody see that okay?
Mm.
All right. So I do real estate E&O for a living, and I do it for your market centers. And this call today is to try to walk you through some of the most common claims I'm seeing, things you can do to mitigate claims. I want to start out by giving you some statistics. In 2019, on my program, which is roughly 1,000 companies around the United States, we had 212 lawsuits. In 2020, we had 414 lawsuits. In 2021, we had over 800 lawsuits. So claims have more than quadrupled since 2019. And why is that happening? It's happening for a pretty simple reason. You guys are selling houses in 12 hours with 20 offers and no contingencies and no inspections, and everybody thinks nothing's going to go wrong, and it is. There's simply not enough time or attention being paid in a deal. And frankly, you have buyers with buyer's remorse before they even sign the contract because they know that they're paying the highest prices in the history of the world for a house that can't possibly continue to go up. And they're upset before they even sign the paperwork. So that's what's happening. And so what we need to do is try to avoid those lawsuits. And I think the perception out there is the way to avoid the lawsuit is to do everything by the letter of the law. And that's not the way to prevent the lawsuit. That's the minimum standard by which you should be operating. The way to prevent a lawsuit is to know the things that are most likely to get you sued and to be very aware and cautious in the deal on those particular points and educate the buyer or seller on those particular points as being the things that are most likely to lead to a claim. So if you assume you may be sued, you're just going to take more precaution. So the standard is not to do what the law says you should do. The standard is to make sure that you avoid the things that are most likely to lead to a lawsuit. I want to start out with just a quick note. I usually end on this slide, but I want to begin with it. These are the things that you should be reporting as notices of claims or potential claims. Yesterday, I got 2 claim denials, and I wanted to bring that up. The most common reason, it accounts for roughly 99% of all denials of lawsuits, that claims get denied is because you had knowledge of an incident and you did not report it to the carrier. So the 2 I want to bring up, one was there was a disciplinary proceeding complaint against an agent 6 months ago. That was never reported to the insurance carrier. The same issue that led to the disciplinary proceeding led to a subsequent lawsuit 6 months later. The client reported that lawsuit 6 months after, and it got denied by the carrier because they knew about it for 6 months and never told anybody. You are required under all E&O policies to require claims and potential claims as soon as practicable. Realistically, that means you have about 60 days at the absolute latest to notify the carrier of a claim or a potential claim. Ideally, I'd like to know about it within a week of you guys finding out about it. I had another claim where somebody was about to go to the closing table. They made a mistake. They knew they made a mistake, my agent did, which was about a $3,000 mistake. And she just said, well, I'm just going to pay it out of my commission, get this deal done, because we're going to close tomorrow and we got to get it done. I said, don't do that. You do that and you settle, you can't then go back to the carrier and say, hey, I just paid this person $3,000, now pay me. I had another person sell a home where they said the chandeliers were going to convey, and the chandeliers did not convey. They made a mistake. So the agent said, "Well, I'm just going to take $10,000 for these chandeliers out of my commission, and then I'll tell the insurance carrier about it." In both cases, the claim was denied. You cannot settle a claim or offer to settle a claim before you notify the insurance carrier, because the insurance carrier could say, "Well, I would not have agreed to that. I would have agreed to something else." You prejudice the outcome of this claim before you involve the insurance carrier. So what should you be reporting? Actual claims, obviously, demands for payment, threats of a lawsuit, disciplinary proceedings or complaints brought through the real estate commission or some other regulatory body, or knowledge of something that a reasonable person would expect would result in a lawsuit. So if somebody calls you and says, "Hey, I'm on the way to the hospital. That house you sold me has mold. My kid's sick, God forbid. You better call me." If somebody says, "You told me that house was on city sewer, it's on septic. You better call me. You're getting sued." If they say, "You told me the garage conveyed with the house and it doesn't," getting sued. So if you reasonably expect that a lawsuit is coming, call me. If you don't know if this falls into reasonably expecting a lawsuit is coming, call me, and I'll tell you whether or not it is reasonably expected, because I have E&O, and then it's on me and not on you. But what we don't want to do is put you guys in a position where you are on a claim that you cannot have coverage for through the carrier, yet you've been paying money for E&O for years and years and years. That doesn't make any sense. And in fact, the comment from the client yesterday with the claim denial, who knew about it for 6 months and never reported the original disciplinary proceeding incident, was, "Well, what am I paying for E&O for if I don't have coverage when a claim comes up?" I said, "No, you're paying for coverage on E&O, but that doesn't mean it doesn't come with parameters. There are parameters. You have to meet those parameters in order to qualify for coverage. One of those parameters is that you notify the carrier in a reasonable amount of time." So I just want to make that really clear. Talk to your OP, your MCA, your PB. If you have a claim, threat, or you reasonably believe one's coming, or you don't know if it falls into that category, call somebody. Find out. And chime in with questions at any point if you have them. I'm a big fan of interruptions, because I think the more interactive this is, the better it is for you. All right, so these are the most common lawsuits within real estate E&O. And number one is always failure to advise previous water damage. Nothing's even close. And so my recommendation is, and I'm in the process of selling my house in Maryland, and the realtor sent me over the form to fill out, and he didn't say a word to me about any of these things. But if your clients know that the most common lawsuit in real estate is for failure to advise water damage, that's helpful to them. Then they understand, "Oh, well, I really need to pay attention to this. This is important." And in my opinion, you want to do everything possible to help them remember the things that they should be telling you about. Did you ever have a sideways 5-year rain that flooded your attic? Have you ever had blowers in your house? Do you ever have your floorboards replaced for moisture damage? Do you ever have to replace your floors because your dishwasher leaked, your washing machine leaked, your dehumidifier leaked? Help them remember, because sometimes people forget that they had previous water damage, or they think, "Oh, I repaired it, so I don't need to report it." If you overreport, you are never going to be sued. If you underreport, you can. So overreport is the goal here. The number two claim is sewer septic, and 11% of all claims last year were where the home was really on septic, but it was disclosed as city sewer. 11%. And to me, this seems insane, because it seems like a 100% preventable lawsuit. But you should be verifying, corroborating whether the home is on city sewer or septic. Do not take the seller's word for it. You should be looking at a utility bill, city records, whatever, to verify that the home is on what the seller is telling you it's on. HOA assessments and permits My mother got pulled into a lawsuit. She lived in the Barrens up there in New Jersey in Basking Ridge. There was a heavy snowfall one winter and a special HOA assessment as a result of that heavy snowfall. And then my mom moved, and then they issued this special assessment, and the new buyer sued. Of course, they lost because my mom didn't know that this new assessment hadn't passed at the time that the house was sold. But you do want to check for any special assessments. And with permits, I see a ton of lawsuits with homes being listed as a 3 bedroom, but they didn't get proper permits and it really should have been listed as a 2 bedroom. You need to make sure that the permits were issued properly and that your listing matches the actual permit usage of the home. Then with repairs, and this goes back to reporting a claim. You know, a lot of people think, well, this claim is not a big deal. I can get this resolved. I can handle this. Or it's not a lot of money and I don't want to turn it under the E&O because we have a deductible, or I don't want our E&O premiums to come up. So I had somebody who was in that situation who had a $1,500 roof repair. They said, I don't want to ding the E&O. I'm gonna do it myself. They had a relative who was a general contractor who they brought over to do the roof repair. And they did a shoddy job, and the roof leaked, and it sparked a fire, and the house burned down. So now the $1,500 roof leak claim that they didn't want to turn in turned into a $450,000 house replacement claim, which was denied by the E&O carrier because they knew about it and never reported it. So my job is to try to see, 10 miles down the road is what might come up, and to try to get you guys thinking 10 miles down the road as well. So always call me or talk to your OP, PB, MCA, whoever there about whether you should be turning it in. And don't think that you can handle it, save the day. Maybe you can. I don't underestimate you, but it may go sideways. And if it goes sideways, you want to, there.
I have a question.
Please.
So when you were talking about permits, so how, like, I understand the bedroom example you gave, but what if like you have a listing and, like, how do you know what a permit is required for? Like, if they did something over, like a kitchen or something, and didn't get permits, how do we find out that information of what would be required to have a permit?
And my answer is I don't know. I'm not on that end of things, but I'm sure your principal broker and the real estate commission can let you know exactly what you're supposed to be aware of, check on. It may be the title company that checks on those things. I'm not really sure, but I'm not knowledgeable on that end of things. I just know the real estate E&O side of things. So I'm sure they can chime in and if any of them are on the call.
Okay, thanks.
I have a comment. I always pull an Oprah report from the house I'm listing, or if I'm representing the buyer. And this way, what permits have been pulled. And then it should coincide with, the kitchen was renovated or the bathroom was renovated. So that's easy to do as an agent. You can do it on behalf of your clients. That's it.
So other top claims are bodily injury, property damage. I've had three claims. One of them happened up in New Jersey where somebody went to show a home and a potential buyer got bitten by a dog or fell downstairs. One of them, I think it's also up in Jersey. Somebody was staging a home, took a large door off the hinges because they thought it looked good for staging purposes, and it wound up falling over on an elderly woman who was looking at the property. So those bodily injury, property damage are pretty common. Obviously, complaints about escrow. Yeah, I want my money back. You're not legally allowed to return the money, so they sue you because they want you to, even though you're not allowed to give it to them. Solar panels. This came up as an issue. I did Michael Brand's Market Center up in Morristown. We did a Scared Straight class for them, and this came up. as an issue in their market center that somebody was going to sell a home with solar panels, and I guess, or was going to take the solar panels with her, the seller was, and she found out how expensive it was going to be to actually remove them and take them with her, and decided, I can't afford to do that. I'm just going to include them with the sale of the home. And then the buyer didn't qualify for the loan anymore because it increased the value of the home to have those solar panels and the lease for the solar panels included in the sale. And the deal was going to fall apart for failing to disclose that the solar panels were going to convey with the home. There are issues around solar panels, and I'm absolutely not an expert on the issues, but I know more and more homes have solar panels in them. And when you see there's a solar panel, you need to talk to somebody and know what questions to ask, because there are definitely questions to ask. And then on wire fraud is not an E&O coverage, it's a cyber liability coverage, but I want to bring it up to let you know just a little bit about what it is. Wire fraud, which is the #1 cyber claim, which most people think is under E&O, is when you guys click on an email that you shouldn't have. And it happens. These guys are getting really good at these scams. And I get 5 emails a day that are scams, maybe more. I get 2 calls from the IRS. I get text messages. It's absurd what's happening right now. But when you get breached and the bad guy gets information about your client, they contact your client posing as you, telling your client to wire funds. That's third-party wire fraud. And the best way to avoid it is not to put another disclaimer on an email that's 10 pages long, where they're not going to read it, just like they're not reading everything in the contract, even though they should. Again, this is the difference between doing what the law says you should do and preventing the lawsuit. Prevent the lawsuit. When you talk to them for the first time, hey, I'm Paul. I'm never going to ask you to wire funds. Why'd you tell me that? Well, I'm just trying to get that to stick in your head. Send them a text message. Hey, it's Paul. I'm never going to ask you to wire funds. Why did you send me that? I'm just sending that because it's really common, and I want you to know up front, I'm never going to ask you to wire money. They're going to remember that conversation because it's going to appear strange to them. Bring it up. Talk to them about it. Don't just put it in a disclosure in the bottom of an email and think that you put it there and therefore you're covered. It's not going to cover you if you get sued. Most of these lawsuits that I'm going to talk about are absolute garbage lawsuits where you did nothing wrong. But they're going to say that you were an expert in real estate. You should have known. You should have told them. You should have held their hand. Even if you disclosed it, they're going to say, well, that contract's 100 pages long. You should have told me. And it's ridiculous that you're going to be held responsible for it, but that's what the legal system is. The legal system is to protect the little guy and not the big guy, and you're the big guy. You're the company. So what I'm trying to do here is get you to think to prevent a lawsuit, not just to do everything that you think is going to allow you to prevail in a lawsuit. Prevent the lawsuit.
I just have a quick question, if that's okay.
Yeah.
So regarding Oprah reports, I'm sorry to bring it back a little bit. I was told recently that we are not supposed to be running them as agents anymore, because if something does not come up, and especially like there's a lot of what I've noticed from doing them for different towns, a lot of towns now, they don't just accept the Oprah form anymore. You have to go in and look for all the different permits yourself. They don't send you like a packet of it. It's a liability on us, because if something that we claim we ran the Oprah report, let's say we didn't find one permit and then down the line, the new buyer is going to sell it, then, what's it called? And then they say, well, this agent ran the Oprah report, they didn't give it to us, then we're at a liability. So I was told not to be running the Oprah reports as an agent anymore. So I just wanted to know if you could comment on that.
I wouldn't be knowledgeable on that, but your principals and brokers can give you some feedback on that, but I'm not knowledgeable on that.
Okay, I just wasn't sure if there was something with the E&O about that, because I saw some talk about the in the chat on the Oprahs.
Yeah, there's no requirements in the E&O that would preclude coverage for not getting an OP report or getting an OP report, or how you handle those reports. That doesn't in any way impact the E&O, other than you might get sued if you don't do things properly, but it doesn't impact your coverage.
Okay, thank you.
Okay, these are the top scenarios that are going to produce a claim. In other words, the things that are most likely to get you sued. So I think these are particularly important to be aware of. The number one, and there's nothing even close, is if a client on either side of the deal is an attorney, your chance of being sued exponentially increases. Sad statement about attorneys, but it's true statistically. So if you have a client on either side who's an attorney, just be really careful and know they know the law. They are looking for a reason to get their kitchen remodeled on your expense. Uh, Flipping properties. Uh, Flipping properties. One of my Keller Market Centers, it may have been one of the ones on the call today, had an agent flip a home, and she sold it to her maid of honor from her wedding, best friend, who then turned around and sued her. I think there was 30 pages of counts of things she did wrong on the flip renovation of the property. If you guys are flipping property, if somebody moves into a property that you flipped and there's anything wrong with the home, there is a 100% chance they are going to say that you knew about it and didn't fix it because you wanted to save money on the flip. There's virtually no chance they're going to say anything other than you knew about it, but you didn't want to spend the money to fix it. You need the roof repaired, you knew that roof had to be repaired. The HVAC had to go, you knew it was 20 years old and needed to be replaced. What do you mean you didn't know there were copper pipes or whatever? You know, you tore out the walls in the kitchen. How did you not know that? You know, they are going to allege that you knew about it. So selling agent owns, specifically with properties that you do any kind of renovation work on, is especially dangerous, and you have to be extremely careful. And you know, when you own it, but you didn't do any repair work to it, they're still going to hold you to a higher standard of knowledge of everything that's wrong with the property than a third party transaction where maybe the seller just didn't tell you. Maybe the seller didn't know. Maybe the person who the seller bought it from originally never disclosed it to them. There are degrees of separation when you're not the owner of the property, but when you own it and when you renovate it, you're really going to be liable. uh, Dual agency, intermediary transaction brokerage, anything where your office is collecting commission on both sides of a deal is especially dangerous. I had a deal fall apart 2 weeks ago where one of the agents who represented the buyer asked the seller agent, "Are there any other offers on the property?" after he had turned in an offer. And the seller agent said, "No, you're the only offer." The buyer agent went back to his client and said, "You're the only offer." And he said, "Well, lower it by $150,000." And they revised their offer down $150,000. And the seller found out that that was disclosed. And I don't know if it's even allowed in or not allowed in your state, because I know there's different state laws. But the seller wound up suing because they lost out on $150,000. And they said, "Why'd you tell them? They had an offer that was $150,000 higher and you disclosed it." That really only happened because they were in the same office. They were friends with each other, sat across the hall from each other pre-COVID. Anyway, there are things that you do. I know my business partner had a dual agency on the sale of his home, and the buyer's agent asked the seller agent, my business partner's agent, "Can we come in and do an inspection?" And they said, "Yeah, sure," just because they knew each other and thought it was okay, but my business partner never agreed to it. Of course, we didn't sue because we do this for a living and we don't do that. But you could have, we could have, because you have to get consent from both sides to do that inspection. But anyway, when you're on both sides of a deal, sometimes you know things that you shouldn't know. Sometimes you take liberties because you think there's some comfort level there with the other agent, and you have to be really careful. And by the way, the states that don't allow dual agency, Texas, I think Jersey, Florida have the highest incidence of dual agency claims, meaning the highest incidence of claims where you're on both sides of a deal. So the states that don't allow it have the highest percentage of claims from that. Why is that? Because people think that they're protected when they're not doing dual agency. And the truth is, you're really not protected. The claim is always you made 6%, 5%, whatever commission, you wanted your money, and you didn't disclose something that somebody in your office knew about. And that persists whether or not you were actually representing one side or not. Sense. And then the other most common claim is on estate sales. You just got to be really careful. You're dealing with death, family, and money rolled up together into one deal. And that creates very tense situations. I've had a lot of claims where one member of the family doesn't agree to the sale. But there is an executor to the estate who's working with a real estate agent who says, yeah, I agree to sell it. I agree on the sale price. But then one member of the family says, I didn't agree to that. I don't want to do this. So you want to make sure you're checking with all members of the family. I don't know what the state law is with regard to that, but I'm telling you that lawsuit comes up frequently. Be careful.
I have a question
Please.
about that. Can I interrupt?
Yeah, please.
Oh, sorry. So I've done a couple of estate sales recently, but I was always under the impression that the executor or the administrator, depending on the situation, has the legal authority to negotiate that sale, and we don't have to go to the other people in the family because the law has given that authority to the executor or the administrator.
Yeah, I would tell you that I've had many lawsuits about this very topic, but I'm aware that state law varies. And my suggestion would be to chat with your principal broker and potentially a attorney if you guys have an in-house counsel, and if not, the Association of Realtors, to pose this very question, because I think it's a good one to ask on what you should be doing. And again, there may be a distinction between what the law requires you to do and that which prevents the lawsuit. So the law may only require that you abide by with the single executor to the estate request, but that doesn't mean that they can't come back, the family can't come back and sue you, and then it could cost a lot of money. And what you do to mitigate that, I'm not sure. I would check with a local attorney or the state association of realtors to see what they think is the best practice, not what the law says you must do, because you're probably right with regard to accepting the executor's orders. But there may be other contacts within the family that you want to get the blessing of, just to make sure you don't get dragged into a lawsuit. But I'll leave that to you guys. The E&O isn't going to be impacted by that, whichever route you go, other than you may have a higher incidence of claims. All right, so I just want to take you through some specific claim scenarios. I want you to be aware there are people whose job it is to entrap you into a fair housing lawsuit. And they do nothing all day but sit home, make phone calls, and call real estate companies and say, I'm on disability. Can I move here? I qualify for low income housing. Can I move in? I have 8 kids. Can I move in? And they wait for somebody to say no. Or I have an assistance pet. It's an iguana, and I want to move into the neighborhood. My doctor prescribed it to me. And they wait for you to say no, and then they sue you. And they have an attorney on standby, and that attorney does nothing but this for a living too. And it's disgusting, but it's real, and they do it. So be aware. When somebody calls you, you never want to say without checking, no, you can't qualify. The HOA doesn't accept that. You want to make sure that you're aware that there are people trying to get you to say you can't rent. Down in North Carolina, I had somebody who had a client that bought a golf villa to rent out for golf vacationers. And a month prior to the close of sale, the HOA had ruled that they were no longer going to allow short-term rentals in the neighborhood. And the buyer didn't disclose it, and the agent never found out about it. And so the intended purpose of the purchase was no longer possible, and the buyer sued and won, of course. So that was just a specific example of a reason why you definitely want to make sure you're checking the bylaws, the HOA, and make sure that the home can be used for its intended use. And there's no special provisions or changes to the bylaws that would impact the sale. Interesting scenario came up also in New Jersey. Somebody sold a house. 5 years later, they resold the same house. They did not include the original disclosure from 5 years prior. The original disclosure disclosed water damage from 5 years ago. The new owner for the last 5 years did not experience water damage and therefore did not disclose it. They resell the house and the new buyer moves in and winds up having water damage. Called in somebody to do a repair who said, yeah, we were out at this house 6 years ago. And they sued. I don't know what the state law is in New Jersey with regard to providing previous disclosures. My advice is if your office has a previous disclosure, include it. I don't care how far back it goes. The law may say differently. The law may say, if it's over 5 years or second transaction, you don't have to. My opinion is if you know about it and you didn't disclose it, you're getting sued. But anyway, I thought that was interesting. It's something I probably wouldn't have thought of to look for prior scenarios where the home was previously sold in your same office.
Paul, can you hear me?
Yeah. Yep.
Is there any, is there any instance of like plausible deniability in that case? I mean, like if you don't know about it, how would you know to disclose it, right?
Well, you're talking about where your office previously knew about it because your office sold it and had the disclosure?
Oh, no. I'm just talking about an instance where, say, another sale went through at another office and now it's my sale. I didn't disclose it, but then the new buyer finds something.
Yeah, I mean, they could claim that you should have known it because you're a professional realtor and you're omniscient, which is what the allegation is going to be. But no, yeah, you have plausible deniability when it wasn't your office that actually did the sale and had the disclosure in-house. But when it's your office that did the sale on that same property, that's when you're in trouble.
Okay.
Really no way out of that lawsuit. Okay, here are some things that I really don't like. I'd stay away from them completely, if possible. Business brokering, I know some people do it. It's just, most people who do business brokering are just residential real estate agents, just like most people who sell commercial deals are residential real estate agents who aren't specialists in commercial deals or in valuing businesses or in selling businesses, but that deal falls into their lap. So I worry about it. I mean, if you're an expert in it, you're a specialist in commercial, you're a specialist in business brokering, okay. But most of the time, my clients are not specialists in that. It's just a deal falling into their lap, and I worry about it. There's a lot of claims on those things. The buyers are much more sophisticated on a commercial deal and buying businesses. You tend to get people who are buyers who have attorneys on staff who are very able and likely to sue. So just be careful with them. Wholesaling, please don't do. Investments, or not investments, loans. Don't give out loans to your clients. Say, hey, I can fix up this kitchen, I'll really increase the value of the property for you, and then we'll split the profits. I don't even know if that's legal in New Jersey, but a lot of people do it. So don't give out loans to clients. Don't do wholesaling. If you're going to do it, talk to your broker before you're thinking about doing that. If you're going to flip, just be really careful and be aware of how litigious it is when you flip, because there is no chance they're not going to say that you knew about it and didn't fix it. If there's anything wrong, they're going to say it was your fault. And team LLCs, Please don't use the LLC on your business cards, website. You can say, I'm the Paul Bondy team, but you don't want to say, I'm the Paul Bondy team LLC. The LLC is set up for commission collecting on tax purposes. It does not perform real estate services. So you can use the team, but don't use the team LLC. The buyer or client should not know there even is a legal entity that you own that's being used to collect taxes. So on your website, take off the LLC. On your business cards and your email signatures, take off LLC. Just say the Paul Bondy team. Any questions about that? Okay, just to let you guys know, you do have deductible waivers in your policy. I want to let you know about them so you know what to do to qualify. You will get a $5,000 waiver on your deductible on any transaction where you had a home warranty purchased or waived, an inspection performed or waived, you used a state, local board approved or attorney drafted sales contract, and a seller property condition disclosure if it's required by state law, which I know New Jersey does not require. Those are the 4 parameters. I'll say them again. Home warranty purchased or waived, inspection performed or waived, use a state, local board approved sales contract or a seller property condition disclosure if required by state law. If those 4 parameters are met and you subsequently get sued in that transaction, you have a $5,000 waiver of your deductible. It is absolutely in your interest to make sure that those 4 things are met. There are going to be times when you can't meet those. Doing a BPO or property management or commercial deal where you won't be able to get those 4 parameters. In those scenarios, you won't be able to qualify for the deductible waiver. Also, sometimes you're on the wrong end of the deal and you don't represent the buyer. And so you don't know if they waive the inspection or waive the home warranty. Some states have that as part of the standard sale contract. Some do not. If your state does not, then you would need to proactively go out and make sure you're getting an affirmative response of either, yeah, I want the home warranty or I don't. Yes, I want an inspection or I don't. But anyway, if you do those 4 things, you'll waive $5,000 of your deductible.
Could you repeat those 4 again, please? You said them very quickly.
A home warranty purchased or waived, inspection performed or waived, used a state, local board approved or attorney drafted sales contract, and a seller property condition disclosure unless not required by state law. And I ran through that pretty quickly. I'm sorry to be a little bit negative on this topic, but if you sat in my desk and you saw 5 claims a day, every day, you'd get a little jaded. I'm very defensive of you guys because of the garbage I see that you get sued for, but it also makes me very aware of how tenuous it is what you do and how easy it is for somebody to file a lawsuit against you. And it's not about being right or wrong. I think that's the pitfall that most people fall into, is thinking, well, I did it right. What do I have to worry about? Claims get paid out whether you did right or wrong. And it's disgusting, but it's the legal system. And so I'm trying to prevent the claim from happening, not have you do the right things that will make you prevail in the lawsuit. I know you're trying to do that. Everybody wants to follow the law. But if you do some of the things I talked about, you'll prevent getting to the point where you have to prove that by law that you were right. I don't want you in the courtroom, whether you can prove you were right or wrong.
Hey, Paul, quick question. So they've been telling us we should be offering the home warranty and that our seller or our buyer for that matter should say yes or no. So that's what you're referring to with the home warranty?
Yeah, right. They have to affirmatively do it. So in other words, it can't be, here's a checklist of things you can get. By virtue of not checking it, I'm assuming you didn't want it.
Okay.
It's got to be, you can get a home warranty. Do you want it, yes or no?
That's really good to know. And then the seller property disclosure. I don't think it's required in the state of New Jersey. Does anybody, do you know?
It's not. I'm almost positive it's not.
So I know that,
It's not required.
right, it's not. So I think there's mixed reviews. Some people say, I don't want to sign it. And we always, we often say the buyers would like, it's to the best of your knowledge, but are these sellers really held to whatever they write there? Because I review them before I send them as, a listing agent, and half the time they don't even answer the questions right, and I have to review it with them.
Yeah.
I thought that there were some big brokerages in our neck of the woods who will not take a listing unless there's a seller's disclosure. I think the blue people, the yellow people are like that, and I thought Keller Williams was the same. Sally, do you know, would you take a listing if a seller refused to sign a property disclosure?
Our policy is that we prefer that the seller fill the whole thing out. But at a minimum, we want the seller to sign it. Because really it's partly to protect you, the agent.
Well, that's what
that
I thought.
the seller
Yeah.
is answering questions and making claims. And if some of them turn out to be fraudulent, at least it was the seller who said it, not you.
Exactly.
Correct.
Yeah.
Mhm.
I have a couple of questions. One is that if a seller takes out a home warranty on their own property for years, the typical term, does that help prevent them against claims?
Yeah, well, it has to convey to the buyer, obviously. So the buyer having a home warranty in place, but if it conveys, yeah, that protects for sure.
Right, a term of 1 year would be okay then. Because,
Yeah, and in fact, on my house in Maryland that I'm selling, I've had problems with my AC, and I'm making sure that the agent discloses that I bought a home warranty because I've been having problems with my AC, and I keep having to put Freon in, so I know there's a leak somewhere, and eventually it's going to go out. And I don't want the buyer to move in, call somebody, and say, "Oh yeah, we were out at this house. We know that there was a problem," and then say, "I didn't disclose it." I want to disclose it, and that's the kind of thing you want to talk to your sellers about. Do you have a home warranty? Oh, did you get it because you have a problem? I know it seems like you're prying into the business, like looking for problems, but that's going to avoid the lawsuit, is to find those problems in advance and disclose them. Flip side of that is it makes it maybe harder to sell the home, but that, to me, that's a small price to pay to avoid litigation.
all right, the other question is, this often happens when you're going through a basement, for instance. As an agent, you see something that looks like it was water damage, and you ask the seller about that, and they say, no, there's no water damage. Or they say it was just a leaky washing machine, but you see 3-4 inches of possible indication that it was something else. And
Yeah.
but they refuse to put that on the seller's disclosure. I don't think an agent can go and amend or add comments on seller's disclosure. So how does that work? Because we saw it, but the seller won't take responsibility for it.
Yeah, that's a question for your PB. My advice would be you absolutely have knowledge of it now. If you believe that to be the case, that there was water damage, and it's your responsibility to disclose it as far as a lawsuit is concerned. As far as what your internal policy is, what the state of New Jersey says you need to do, if you contradict or conflict with or have different insight from the seller, I don't know what the law says you should do. But it for sure is going to get you in a lawsuit.
Paul, could you say something about, you've talked about deductibles. What is that? Does is there a deductible that all the agents have to pay if they get sued and lose?
Well,
Or
there's
is
a
it first
deductible on the policy, and it's irrespective of whether you win or lose. It says that the first, whatever your deductible is, I don't recall what your market center deductible is, but it's usually somewhere between $2,500 and $10,000. The agent is responsible, or the market center is responsible for, on any claim. That's in legal fees, damages, whatever it is. The first, whatever your deductible is, worth of the claim, you're responsible for. And then, the market center may decide on a different number. They may charge back the entire amount. They may make it more, they may make it less. That's an internal decision, what you're responsible to pay. But the deductible is there on each claim, and it is capped to 3 times. So once you hit 3 times the deductible on the policy, there's no more deductible in the event of future claims. So if you had 30 claims in a year, God forbid, you wouldn't need to pay a deductible on 30 claims. You'd pay until you hit 3 deductibles, and then you'd be capped out. But the market center may decide differently. They may make you pay a deductible regardless.
So we need to find that information out from our own market center.
Yep.
Okay.
Hi, Paul. Can I ask you a quick question? Nancy Yang here. I was a little bit late. You might have touched on this point, but I'm just curious. Is there, for like, we're talking about possible lawsuits against agents. In the industry, is there such a thing as like a valid period of time during which lawsuits could happen?
Sure.
That's
Yeah,
a good
every
question.
state has a statute of limitations.
Statute of
It gets a little confusing because the statute varies by the kind of claim. So fair housing has one statute, bodily injury has another, mold has another, contract law has another. So depending on what it is that they're suing you for, the statute varies. There are some things that have no statute, or rather the statute begins upon knowledge. So just as an example, if you sell a house and it's got mold and the buyer doesn't find out for 4 years that it has mold, the statute begins when they discover the mold. It doesn't begin at the time of sale. I had a friend of mine in high school who got operated on, and the doctor left scissors in him. Well, he found out like 5 years later that he had scissors in him when he got an x-ray. And that's when his statute began, when he discovered it. So there are some things that are like that. And then I have lawsuits that are beyond the statute. And he said, well, how can somebody sue you beyond the statute of limitations? Well, they can sue you. They may not win, but they can try. And then you have to defend it. But usually the statute is 2 years. That's the normal statute of limitations for most states. And 4 years pretty much exhausts everything other than the things where the statute begins upon discovery of the problem.
Thank you very much. So it sounds like if it has to do with environmental, they have much tougher rules on that, right?
Yeah, I think mold has a longer statute than contract law. I'm pretty sure contract law in Jersey, don't quote me on it, but I'm pretty sure it's 2 years. And I think fair housing is the same, but I think with mold is 4, but you have to check with the state. I just don't recall. I write in every state, so they get a little confused in my head what the statute is with every state. But the Association of Realtors for sure can tell you if you wanted to check with them.
Thank you.
I have a quick question. Do you recommend that we open LLCs to protect our personal assets?
That's a legal question. I would ask a local lawyer about it. To me, it just sounds like you're adding another person to drag into a lawsuit. You're performing the transaction on behalf of the legal entity. I mean, if I went for AT&T, I wouldn't go get a personal policy because really wouldn't be any reason for somebody to sue me personally outside of the services I perform on behalf of the entity who employs me or as an independent contractor or an employee. So I don't think so, but a lawyer may think differently. I don't see how it's possible to get sued personally when you're acting on behalf of the real estate company, unless you're doing something personally. So if you're flipping properties and buying homes as investment properties to sell them, that's a different scenario. Now you actually are performing services under that LLC. But just to have an LLC that's not performing any services, just so you have something as protection, I don't really see it, but I'd ask an attorney.
Okay, thanks.
Can a broker sue an agent on any of these issues for non-disclosure?
Can like one agent sue another one?
No, a broker, like, or the owner of the agency.
No, I'm not covered under an E&O policy. It couldn't. Not legally, I don't know. But there's an insured versus insured provision in the E&O policy that says you can't sue yourself, basically, which any insured isn't insured. So all the agents there, broker, independent contractors, they're all insured. So you can't sue each other and have coverage under the E&O policy. It would include buying a home from one another. Whether the law allows it, I don't know.
Thank you.
Yeah, but I know brokers have had licenses suspended because of the activities of an agent. So I could see that being a really viable claim, but it's not an E&O claim.
Oh, so that would be a separate lawsuit outside of an E&O claim.
Yeah, right. Exactly.
Okay. Okay, thank you.
Sally, without mentioning any names, does Keller Williams Village Square get many situations, lawsuits? I mean, obviously Paul's been talking in general terms, covering a lot of brokerages, a lot of market centers, but I just wondered how Village Square stacks up.
We have done pretty well. Not to say we've never had a lawsuit, but I think considering the number of people we have, Paul, you can react to that, but I
I'll
think.
pull it up and I'll tell you.
What's that?
I'll pull it up now and I'll take a look and I'll tell you.
Yeah. The other thing, Paul, there was one slide that I think you skipped over. Maybe the one about having unlicensed people at an open house.
Yeah, I was just trying to speed up and remove a
Yeah,
couple things.
could you just
weren't-
address that? Because there are people who sometimes want to take their son or a friend or someone who's not licensed. So if you could just touch on that.
Yeah, the scenario that came up for me was pre-COVID when people were going out and doing more open houses. I guess things are more back to normal now. But an agent, who worked for a big team was really busy, and they couldn't get to the open house, so they sent their unlicensed assistant to the open house. And somebody asked a question about the square footage of the property, and they didn't want to seem unknowledgeable. Didn't want to embarrass their team leader, so they just said what they thought was the answer, and they were wrong, and they wound up causing a lawsuit. But Joe, people get put on the spot and ask questions, and they don't want to seem like they don't know the answer and feel embarrassed or think it's embarrassing for the team if they don't know what they're talking about. So they gave an answer. So it was just a message just to make sure that your unlicensed assistants, if people are helping like that, aren't giving any information about the property, because it can come back against you.
And I would just add to that, even if you're a licensed agent and somebody asks you a question and you're not sure of the answer, don't give an answer. Tell them you'll get back to them. Don't risk telling them the wrong thing.
Yeah, so let's see, Village Square, how many transactions do you do a year? Okay, yeah, so statistically, it's roughly 1 in 900 transactions results in a lawsuit. And you guys do 2,600 and change transactions a year. So it should be actuarially anticipated that you have 3 claims a year. So you guys are in a good ballpark. You do below the statistical norm with claims. So the market center is doing what I would expect any good performing client to do. But you can't avoid a lawsuit. There's too many idiots, sorry to say it. And if you do that many transactions, the law of large numbers is going to happen. You're going to get sued. It's impossible. I have no clients, I mean none, who do 2,000 deals a year and have no claims. Some people choose to handle the claims on their own and not turn them into E&O, but we talk about them. But nobody just winds up not having a claim because they do things so well. It's not about you doing things so well. It's about clients being mad and suing you because you didn't tell them that there were termites through walls that you don't have X-ray vision to see. You know, so if the seller doesn't tell you things, you can't know. You're going to be sued for not disclosing those things that the seller didn't tell you about. Why, in my opinion, want to go out of your way to get them to talk about those things so that they do disclose it so that you don't get sued in the first place. Instead of relying on, I didn't know, the seller never told me. That's my defense. That's not going to win you a lot of lawsuits, even though it should win you a lot of lawsuits. Not going to.
Can you tell the seller that they can be sued as well? I mean, that might help them
Sure.
disclose.
That's, yeah, absolutely. They can be sued for not disclosing. And that's why I bring up, I would tell people, these are the number one claims or the top claims in real estate for failing to disclose previous water damage and not properly disclosing HOA assessments and permits on changes you've made to the house, upgrades you've made to the house, and sewer septic. I would let them know that, get them thinking about that. You know, I don't want them just glossing over whether they really know that there was a previous issue with water in the home, or maybe they think there was something. I'll tell you about one other claim that happened because I think it was crazy, but it goes to how crazy it is. Somebody was selling their house in the wintertime, and the agent said, we're going to be doing a lot of showings. You probably want to get oil put in your furnace so that when we bring people in the house, we can turn it on. There's plenty of oil to heat the home for these open houses. And it was like an elderly woman. And she said, great, I'll do that. And somebody came and dumped, 1,000 gallons or whatever it is into her basement. And it flooded the whole basement because she didn't have an oil tank. She had replaced her home with natural gas and forgot. And the agent had suggested, and then the agent got sued for saying you should do that. Like, how is the agent supposed to know that they changed the home or converted it to natural gas? I mean, you would think that the homeowner is going to check before they bring in a truck to dump oil in your basement. The lawsuits I see are outrageous. The things that they're holding you guys responsible for are outrageous. But it happens. So all I can do is try to keep you from getting into that courtroom in the first place, because you're going to get gray hair if you get in there, whether you were right or wrong.
I've heard agents say that since sales disclosure is discretionary to be filled out in New Jersey, that it's okay if sellers don't fill them out because what you don't know can't hurt you, essentially. And that's the seller's position, and that's an agent's position too. But
Yeah, I don't like it.
Yeah.
I'm totally against it. I think it totally leads to a lawsuit. The fact that in 2009, 2010, foreclosure claims were rampant. The lawsuits were off the charts because everybody thought as is meant as is. That wasn't the case. This is my same problem with the lack of disclosures. Just because you think the law says, hey, if they say no disclosure, then how could you be held accountable if there's really something there? You absolutely can. For anybody to say otherwise, they're not looking at the lawsuit. It doesn't follow the facts. So I would strongly urge to get a disclosure. If it were me, I'm not on your end, but I wouldn't do it if there were no disclosure. Personally, at least it gives you some protection, but the law doesn't say you need to. And some people tell me that New Jersey, the Association of Realtors and the Lawyers Associations up there are saying that they'd prefer you not get it. To me, that sounds crazy.
I'm not sure that's true, Paul.
No. Yeah, I
I'm
don't
just
know.
talking about individual agents and sellers. You know, some agents feel they're more protected if the sellers don't fill out a seller's disclosure. And some sellers feel the same way. It's not this is just individuals, not professional organizations with that point of view.
Yeah, I disagree with that philosophy personally.
The seller disclosure can protect you, not unprotect you.
Right.
All right, well, if anybody thinks of anything, I think you guys we're going to record this call, and you're welcome to disseminate the presentation. And anybody who has questions, you're welcome to call me, contact your broker, MCA, OP, team leader, and ask questions. I'm happy to answer them.
Thank you very much.
All right, thanks everybody.
Thank you. Thank you very
Thank
much.
you, Paul.
Yeah,
Thank you.
Bye.
Thank
Great class. Thank you.
Thank you, Paul.